Good morning. This is the New York City Board of Standards and Appeals public hearing for April 1st, 2014. We'll begin with the special order calendar. Decision items, item number 1, 24055BZ, 207-22 Northern Boulevard, Queens.
Good morning, Todd Dale for the applicant.
Motion to grant?
Chair Srinivasan.
Aye.
Vice Chair Collins.
Aye.
Commissioner Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Opley Brown.
Aye.
Thank you.
Continued hearing items. Item number 2, 5-28BZ, 664 New York Avenue, Brooklyn. The office of Eric Palatnik.
Hello, good morning, Madam Chair and members of the board. Eric Palatnik.
Are there any questions for the applicant?
I just had the
Yes.
one comment that the revised site plan, there's quite a bit of writing that's not legible. It's very, very faint, the parking alignment, so if that could be,
We'll bold it
Darken
out
it.
and darken it up. I think
Yes.
it came out that way in a PDF probably when it was transferred. We'll
it's
sharpen it up.
Z002.03.
You could work with Carlo on making sure your plans are acceptable.
We'll be happy to.
Are there any speakers on this item? Right, if there are no speakers, we can close the hearing. We'll leave the record open for you to make a submission.
Thank you.
And submit to us, you submit to us in a week?
Yes.
Okay, so that's, 2 weeks. April 15th, we can vote this out on April 29th.
Thank you.
Make a motion to close.
Chair Srinivasan.
Aye.
Vice Chair Collins. Aye. Commissioner Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
New cases, item number 3, calendar number 15602BZ, 964 65th Street, Brooklyn, Herrick Feinstein.
Morning, Jennifer Dixon for the applicant. There were a few questions that came up yesterday at review session I just wanted to address. The first regarding the property and the back portion of the property behind the proposed parking lot. Just wanted to point it out on here on the site plan. The boundary of the property goes like this. And this portion back here is not currently within the boundary of the existing fence of the existing lot. That portion appears to be used, and it is used, as part of the backyards of the residential properties that face out onto 66th Street. It's paved with concrete for the most part, and there's nothing on it except there is like one small shed right here. And that's 2 different residential properties. We looked into this. This wasn't something that Chase was aware of, so it seems to have been a historic condition that has existed at least since before the approval of the last renewal of the variance application. The site is shown in this shape, but the actual boundaries of the usage of the site are smaller. So Chase does not have any intention of going into that area. They just thought it was more straightforward to leave it as is. So the plan is to have the parking lot within the boundaries of that fence.
Okay.
So the zoning lot won't change at all?
Correct. They're going to
boundaries-
keep the zoning lot as is, and the boundaries of the parking lot will be kept as is shown on the site plan today.
And it's all residential uses back there?
Yes, those are it's 2 residential backyards.
Thank you.
There was a question just about the material of the fence that surrounds the property. So currently today, there is a metal fence that has a green plastic material woven into it that's meant for opaque shading, and the intention is to keep that fence as is.
My request was just to note that on the plans, not to say existing fence, but what the
Sure.
fence is.
Okay, so we could definitely make a notation on the plan to note that.
Okay, and the landscaping along, what street is that?
65th?
Yes, along 65th, exactly. So the landscaping's outbound of the fence, or is it?
The
inbound?
landscaping is inbound of the fence.
Okay. All right, so if you could, where is the fence?
The fence goes, the
Okay.
fence is just at the property line, and then all of the landscaping is on the inside.
Okay. All right, we had a few other questions. Yes.
Sure, and then just regarding the community board recommendation, so they were concerned primarily, I would say, with 2 things. One was having the parking lot be closed after hours, and the other one was just making sure that nobody other than Chase customers utilize the parking lot. So what we have proposed to do in terms of closing down the parking lot at night, and currently the hours of operation of the bank are from 8:30 a.m. to 6 p.m. on Monday through Friday, and 9 a.m. to 3 p.m. on Saturday. Chase has used this in other lots. It's basically a removable post and chain enclosure. And we note it on the plan, they would put it up basically here. And that would have like bollards and posts that go into place after hours, and then there would be a metal chain link fence, and there would be a sign on it that says parking lot is closed. The reason why we're proposing to leave open spaces is because there's a 24-hour ATM in the bank, so we don't want to have the parking lot completely closed because there needs to be a place to park to use that ATM. And the configuration as to how we proposed it that way is for two reasons. One is because the concern was not to have the parking overnight adjacent to the residential uses, so it's kept away from the residential uses on 65th and then 66 behind the property. And then also we just needed to have some maneuverability for the cars to get in and out of the lot.
Okay, so I can see it on the plan, but it runs through a parking spot like in the middle. Is that because some of the space is for maneuvering?
It's just for maneuvering, so that parking spot would not be usable overnight.
So the number of open parking spaces would be how many in the end?
There would be 4 non-handicap parking spaces
Okay,
and then the 2 handicap parking spaces.
Okay, is there, can you show us a detail of what this system is? From a
I'm
photo?
sure we have a photo
That'll
that we
be
can
great.
submit.
Okay. All right, and I think they had just a few other questions, right, about the DEC spill and everything's cleaned up on the site?
Right, so we can't get a permit for the work on the lot unless everything is completely clean. So we would follow the process of the Department of Buildings to do that. That's the intention. In terms of closing it to non-Chase customers, we are proposing to put signs up within the lot that says parking for Chase customers only. This is something else that Chase has employed at different lots, and they would contract with the towing company if there's somebody who's really violating that and using the lot for different purposes. So that's the plan there.
And does the site plan identify where those signs would be? And
It does. I don't know. We probably could put another arrow on there because they're dashed in these lines, and then there's a detail of the sign at the top of the plan, but we could certainly make that clearer.
okay, but the signs are actually inside of the parking lot. Is
Yes.
that correct?
Yes.
Does it make sense for you to provide a sign at least in the entrance, so when people are coming in, they know that they shouldn't be in? Can you take a look at that, right?
Yeah, we'll take a look
Doesn't
at
that
that,
make
yeah.
sense?
Yeah, that does make
As opposed to
sense.
going in and then finding.
And seeing that it's only a Chase
Right,
lot. Yeah,
right.
that makes sense.
Okay, so if you could take a look at that and maybe just modify your plan and show a location. But, a location where it's visible to people entering the site, but not necessarily to everybody who's on the street.
Right, so we'd probably put it at
Maybe
the
the
level of a
side.
car, not like, so it wouldn't be something sticking up in the air.
Exactly.
Okay.
All right, any other questions? Okay, any speakers on this item? Any speakers? All right, I think we can close the hearing if you could just make these changes and submit to us. If you can submit to us by April 22nd, we can vote this out on May 6th.
Okay, thank you.
Make a motion to close.
Chair Srinivasan?
Aye.
Vice Chair Collins?
Aye.
Commissioner Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Ali Brown?
Aye.
Item number 4, calendar number 17407BZ, 1935 Coney Island Avenue, Brooklyn, Carl A. Safaro.
Good morning, Carl Safaro, applicant, and addressing some items of concern yesterday. Regarding trash pickup, it's our proposal to collect trash not before 7 a.m. and not after 7:30 p.m., 2 or 3 days. We think that should be sufficient, and not on the Sabbath. Be sensitive to religious concerns for residents in the area. As to the dumpster location, we're providing a drive area 12 foot wide. The track width on the truck that collects is 8 foot wide. We think there's sufficient maneuverability space for the truck to enter and back out during these 2 or 3 times of pickup during the week. We are preparing an amended plan package to show you the streetscape, reduced lighting levels. We'll reduce some of the LEDs in the fixtures in the canopy, which will reduce the overall lighting effect, and we'll show that on the revised plans. There actually is very little lateral spillage with the LEDs. They tend to put out a more concentrated beam direct down, But nonetheless, by reducing the number of LEDs, the overall intensity of lighting will be reduced. And we'll show that on the drawing.
Okay.
By the end of the week, we expect to have the Marlboro sign out, so it's not proposed to be continued in any of the new development. So we'll make that accommodation, remove that sign, and also document in writing, make some documentation from MTA that the agreement to move the bus stop will still be in full force and effect, and we'll abide by that.
Okay, great. Are there any other questions for the applicant?
I just had
Yes.
a question. You're moving the store closer to the, I guess it's right on
Yes.
the property line at the sidewalk. Could you just give us a little sort of more detailed streetscape? I think you're just showing us the elevation. Could you show us what it now looks like, say, corner to corner?
I think they said you're planning to give us street.
Yeah, we'll give you a separate sheet, show you
Okay, I
the
didn't hear you say that.
sort of mixed uses up and down Coney Island Avenue, different heights, different sizes. But we'll show you what we see and put it on paper so you can evaluate.
Yeah, that would be helpful.
Very good.
Are there any other questions? Any speakers on this item? All right, Mr. Safaros, so we'll wait your next submission. If you can submit on April 22nd, we can have the hearing on May 6th.
That would be fine.
Thank you.
Yes. Okay, thank you.
Item number 5, calendar number 17707BZ, 886 Glenmore Avenue, Brooklyn, Sheldon Lobel.
Richard Lobel of Sheldon Lobel PC for the applicant. Good morning. Madam Chair, as you are aware, this is an amendment application for originally a two-family home, which we seek through this amendment to be a three-family home. I was at the executive session yesterday, I heard the board's comments, and it seemed that there was little issue with the proposal. I know that there was an internal matter that the chair had raised for the commissioners, which discussed the front yard on Glenmore. I don't know what the disposition of that discussion was.
Commissioners, I don't know if you got a chance to look at it, but if you look at the photographs, you'll see that the adjacent building, I think, has one window, which is going to be blocked in any instance. I think the real problem is that the location of the building right now, vis-à-vis the adjacent residential, is that it sort of blocks off their rear yard and a lot of light and air. If you actually align the building, it'll open up the space at the rear, and it'll align itself with these buildings, and I think it'll have less impact. So from your perspective, is there any concern about moving the building?
No, I mean, the architect and I discussed this. I think that his request was that, or his desire was to minimize the variances that were required.
I understand.
To the extent the chair feels that the character finding here controls, we'd be happy to make that modification, subject to discussing that with our owner, but the architect initially agrees with the chair and thinks that the shifting of the bulk would be in order.
All right, so why don't you provide us with an alternative, and then we can look at it. But I think my instinct is that would make a better solution. Would it require you to get any additional objections, or,
I don't think so.
okay, because you have the front yard?
Correct.
I see, okay.
So we'd be happy to provide that to the board.
Okay, and just a comment for the architect, if they could just make sure that when he presents the drawings to us next time, that they're all oriented in the same manner.
Sure.
Because it was very confusing, and also as a part of that, because by moving the building in front, you have the opportunity to really landscape at what is now the side yard, and if they can show that as well, and provide the streetscapes that go along with it, both along Milford and along Glenmore.
The streetscape on
Milford as well as
Glenmore. Yes, of course.
on Glenmore. Are there any other comments or questions? Okay, so why don't we, any speakers on this item? Any speakers? All right, why don't we continue the hearing? You can submit to us on April 15th. We can bring you back on April 29th.
Madam Chair, to the extent that the corrections and the changes are all in order.
Yes, if it's acceptable, we will consider.
Thank you, Madam Chair.
Appeals calendar. Decision item, Item number 6, calendar number 21513A, 300 Four Corners Road, Staten Island, Anthony A. Lenza.
Applicant here? All right. Motion to grant?
Chair Srinivasan,
No.
Vice Chair Collins,
No.
Commissioner Hingston,
No.
Commissioner Montanez,
No.
Commissioner Otley Brown.
No.
Continued hearings, item number 7, calendar numbers 140 and 141-11A, 6917 38th Avenue, Queens, Sheldon Lobel.
Jordan Most from Sheldon LaBelle on behalf of the applicant.
Any questions for the applicant? Any questions? All right, we have reached out to DOB to speak to the permit. Are there any speakers on this item? Any speakers? All right, I think we could close the hearing. We'll leave the record open for DOB's input. Obviously, if there's some issues, you'd have to cure them at DOB. So why don't we set the decision date for May 6th?
Thank you. If I could just, could I clarify
Yes,
one
you
thing that
can.
was, I know, raised, in that the, I think the objections, there was a question last time, I recall, that the plans were, the modified plans were professionally certified. But I think they were actually, they were plan examined, and the objections were professionally certified. I just wanted to make clear, I don't remember exactly how we discussed it last time, but I saw that on the plans.
Okay.
Thank you.
All right, any other questions on this case? Can make a motion to close?
Chair Srinivasan,
Aye.
Vice Chair Collins.
Aye.
Commissioner Hingston,
Aye.
Commissioner Montanez,
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
Item number 8, calendar number 29613A, 280 Bond Street, Brooklyn, Jack Lester.
Good morning. Jack Lester for the appellants. I believe in the last hearing and through the last submission, the appellants demonstrated through both the evidence and lack of documentation that the active operation of substantially all of the non-conforming use was discontinued. We believe we had demonstrated that at the prior hearing. Now we believe we have overwhelming proof. And we want to start with the questionnaire that the proprietor submitted to the district attorney in 2011. He's the owner of the business. He would be the person in the best position to know whether or not business was continued at the site. And in his questionnaire, he details, he said he had no checking account for 10 years. He had no employees, no business, no bank account. So how could a business possibly have been undertaken at the site without any employees, without any bank account, and certainly no transactions? That was in February of 2011. In July of 2011, the proprietor, the owner of the business, gave a deposition under oath. Now, this would be the second time under oath. In that testimony, he indicated there was no business for 3 years. The only phone bill he submitted through that testimony was connected to 8 West 28th Street. There was no mention of 280 Bond Street through any of the questioning, which was very detailed in terms of what business and what transactions he had undertaken. This was a civil suit to collect the debt, and the deposition was to uncover his assets. There was no mention at all throughout his testimony of 280 Bond Street. In fact, he said the only income he had was through Social Security. He had no other income. And in contradiction of the testimony that we heard here last time from Ms. Ackerman, who was his wife, he said his wife had no income other than part-time employment from the Board of Education. So that's a direct contradiction of the testimony you heard last time.
Can you speak
Sure.
again, just a little bit to what this deposition was about? Because you said it's a civil suit between,
Right, this was a creditor who had already had a judgment, and he was deposed to uncover his assets so they could collect the debt. This was a judgment creditor who now had a right to put him under oath to see where his assets were. And he was very clear throughout the deposition that he had no assets, no business, no income other than Social Security. So this was under oath. But now this was the second time under oath because he had already submitted an affidavit to the district attorney's office, which was very detailed. We attached the whole questionnaire
Right.
to our papers, which we got through the Freedom of Information Act. So that's a highly credible document. We have a witness today, Katya Jestin, who's a former U.S. attorney, who can tell you that when you submit an affidavit to a prosecutorial office, that has to have a high degree of credibility because your freedom is at stake. So he had no motive to lie. In fact, his motive there was to tell the truth. Contrary to the affidavit he submitted here, which was for a very particular purpose. It was, first of all, his affidavit was very generalized and very broad. He doesn't give any specifics. But obviously, if there's a motive to lie, and he's lying in one place, he's either lying to the district attorney or he's lying to this body. And certainly the motive here is clear.
Right, but I'll just tell you, my concern is that I understand there's definitely conflicting evidence.
Right.
And in some ways, they kind of cancel out each other. My
Right.
concern is that this deposition and the questioning wasn't really directly related to the issue before us, and it is contextualized to some degree. So you may have heard at yesterday's review session, I think the board members had raised this as a concern, and, we'll hear from the applicant, but I think
Right.
at best doesn't it just essentially cancel out their affidavit?
Well, I think one could look at it that way. Certainly, practitioners in the law know that the judge will make a charge to a jury that if you believe the witness is lying, or if you can show that the witness is lying, you don't have to credit any of it. You could disregard the entire testimony. However, I take a slightly different tact here. When he gave that questionnaire to the district attorney, I think what makes it more credible on the issue of lack of business is because it was unrelated. He had no reason at that point to say anything other than the truth. If he had business, ongoing business at the time he submitted the questionnaire, that would not have been a negative for him. He had to give an accurate, detailed response as to his financial condition because he was facing, whether it was incarceration or probation, whatever it was. Certainly his lawyer would have advised him to submit a truthful document because to submit an untruthful document to the district attorney's office in the midst of prosecution would have compounded his problems at that point. So I submit that's probably the most credible piece of evidence that this body has, was something unrelated to this proceeding, where he had no motive to lie, where he speaks directly to the issue of whether or not he had business. But we go even beyond that.
Okay.
The lack of evidence, we think, is significant, because as we heard in the last hearing we had, the witnesses were instructed, the witnesses for the owner were instructed to come back with some records. That was the request. Even the DOB said at that point they would have issued a revocation. So there's not enough evidence, we would issue a revocation. So at this juncture, at this hearing now, there are still no business records, none whatsoever. There are no tax records. There are no records of any employees who worked there. There are no invoices, no sales receipts. This is supposedly a plumbing business. There's no record of any plumbing supply deliveries of any kind. No record of dispatches. If this was the location where he was dispatching his employees or contractors to other sites, there's no record of that. There's no record of business vehicles. There's no record of any business expenses whatsoever. So the only thing they have, and what they produced, what the owner produced for this hearing, was that there were permits. There were permits.
Right.
Now, we have testimony, we will have testimony today from a registered architect who will tell you that the permits that were posted with the DOB, so the DOB had these records, don't necessarily, well, in fact, there's no inference should be drawn that those permits were in any way connected to 280 Bond Street. Now, apparently in 2010, Mr. Isakowitz did a job at Beach 100 Street in Far Rockaway, 2010, but there's no way of knowing whether that was connected to his other site in Manhattan, West 28th Street, or was it connected to his home where he ran a business out of his home, because that's an address that's listed as well. But more importantly, even if one were to credit those permits as somehow being connected to 280 Bond Street, there's no record of anything after 2010. The phone listing that's produced by the owner shows a different address. But even, again, if one were to credit those phone listings of having any substantial relation to the site, it shows scant activity. The phone bills, it hardly shows an active business that was dispatching plumbers to sites or taking phone calls. He does produce insurance, but the insurance policies could very well have just been for the site itself, because he had to insure against flood and fires and other things. The insurance documents also indicate doing business at 976 East 10th Street in Brooklyn. Then the affidavits they produced 3 affidavits. One affidavit from a fellow by the name of Mr. German, which ends at 2009. So that doesn't show it. The accountant submits an affidavit without any tax records, but he submits an affidavit saying he stopped doing business or stopped working for Mr. Isakowitz after 2010. And then Seth Nauman, which is an unsworn statement, unless the board has it sworn, I don't know. He says that his last connection was 2010. Then we were very surprised after our submission and the owner's submission. We felt, based upon the DOB's testimony at the last hearing, that they would certainly come back consistent in their submission. But much to our surprise, they came back and they said that they credited the affidavit of someone they believed was lying in 2 other proceedings. There's a little footnote in their submission. They said, well, we credit his affidavit, but it's troublesome to us that he may have been lying to to a governmental official and in a deposition. And somehow they believe that this affidavit then becomes worthy of their worthy of substantiating the use. And they base that, they say, on documents. Again, the permits don't connect to 280 Bond Street. The Verizon bills are very scant. The satellite photos show automobiles parked, but we don't know what those automobiles have to do with anything, and there's no record of what they have to do with. The utility use, one of our community members pointed out to me yesterday that the utility bills were so low they couldn't even heat their apartments, let alone that huge warehouse with the amount of money they were paying monthly on the utilities. And there's no affidavits after 2010. But what was most troublesome to me was that the DOB said that the certificate of occupancy creates some kind of presumption. Now, either I'm missing something or I'm not understanding that argument, because we wouldn't be here contesting the non-conforming use if they didn't have a certificate. Obviously, they have a certificate of occupancy, which allows them to undertake the non-conforming use, which we're challenging. If they had no C of O, we wouldn't be here challenging that. So I think the C of O shows what they're permitted to do, but it doesn't show that there's any activity of any kind. Another issue came up at the last hearing, and it was brought up again in the submission, was what was the standard in the Toys R Us case? And when I testified last time, I was relying on my memory as to what had happened. So I decided to go back into the record and look at the testimony that the BSA had, because I have the transcript, plus the BSA resolution. And what was shown in that case was that Morgan Manhattan Warehouse showed much more activity than what's shown in this case. The warehouse owner came forward with logs, which showed the arrival and departure of trucks. He had a bank account. He had a record of laborers and helpers. He was able to show 40 to 50 accounts, and he was able to show the transfer of goods. And he even testified that he had insurance. Now, why the board found against him and found the discontinuance of the use is because the 40 to 50 accounts represented 5% of the activity. not 1/10 of 1%. Where the 1/10 of 1% comes in is that was the amount of space that was used up in the warehouse. In other words, the amount of goods that he was storing only took up 1/10 of 1% of the entire space. But he was able to show 5% of business activity, which the board said was not sufficient. And again, the board based its decision on limited utility use, scant records of any kind of phone listings at all. And the board found, again, most controlling was the lack of evidence. No tax records, no advertisement, no customer records to substantiate anything beyond the 5%, no employee records except for that one individual who was there, and no legitimate business records. So that's how the board came to their decision. So using that standard in this case, we feel we have much more proof. Well, first of all, there's no evidence of any activity. I mean, as we say in our submission, we could show not only that substantial, a lack of active operation of substantially all, but we show there's no evidence of any activity whatsoever. So we could show almost complete cessation in this case, which we couldn't show in the Toys R Us case. So I think if the hearing were to end, and I said this at the last hearing, I repeat it again, if the hearing were to end today, I think the board would have to revoke the permits. There's no evidence of any use. Thank you.
Thank you, Mr. Lester.
One other point,
Yes.
though, in terms of further testimony. In the Toys R Us case, there was conflicting evidence. We had witnesses who said one thing, the warehouse had witnesses who said another, so the board made a determination to subpoena individuals and put that individual under oath. Here we have the same individual, not two different witnesses giving conflicting evidence, but the same individual giving conflicting evidence. So the appellants would appreciate if the board would issue a subpoena to Mr. Isakowitz and put him under oath and ask him to reconcile the conflicting testimony. I think at the executive session, you indicated that you would like the DOB to reconcile some of this evidence, but I think the burden should be on Mr. Isakowitz to come forward and explain the conflict. Thank you.
Thank you, Mr. Lester. All right, the Buildings Department?
We have witnesses. Should we,
Yes, I
should we
thought
call them now, or?
I think what we'll do is we'll take a testimony from the Buildings Department and the owner, and then we'll open it up to members of the public.
Amanda Sturr,
Witnesses,
Department
yes.
of Buildings. Actually, I was going to recommend that maybe we hear from the owner first, and then I can respond.
Okay, that seems fine. Mr. LaBelle?
Richard Lobel of Sheldon Lobel PC for the owner. Madam Chair, at the prior hearing, the Department of Buildings had reservations. And so they basically said that they'd like to see additional documentation to be submitted by the owner in support of its application. After that submission, which included telephone records, which included records from Verizon, which recognized that there was service at this address dating back to 1982 through 2012, after we submitted evidence of insurance and business insurance, which, by the way, listed this premises at 280 Bond as the sole beneficiary of millions of dollars of insurance. So while other addresses were listed in the policy, when you look at the schedule, which we'll be happy to highlight in our next submission, you actually see that they refer only to 280 Bond. So after showing the phone records, certificates of insurance, after we give evidence of certificates of insurance for automobiles and trucks, after we submit additional third-party affidavits, the Department of Buildings basically weighed in again. And what they do, they basically reaffirmed their initial determination, which is that as of 2012, when the application was brought, there had not been a cessation of business activity at the site for 2 years. So we understand the board's comments with regards to the later years, and we're happy to address that, and we will address that, because frankly, if the application was filed in October 2012 for permits, they would have had to have provided, or would have need to show the continued business activity through October 2010. they wouldn't need to show it through the date of the permits. It would not have been able to cease for 2 years.
Right, but the buildings department's position is that they don't question it if you have a C of O. So I'm not sure that at the time of permits in 2012, anything was provided to DOB showing it up to 2000.
That's fine, but it would have been the relevant date because if business operations had ceased at that date, they would not have had the right to continue.
So you're actually, are you?
No,
saying
we
that-
continue well beyond that point.
Okay.
But I'm just basically, and we'll provide the law behind when we would need to show that documentation until. But my point.
But I just want to point out
Sure.
one flaw in that. So if it was on the date of the permits, they had to show the 2 years before that no more than 2 years had they stopped working there or had a business, it would really mean that any use at that site would take place as of October 2012. So we know it didn't. So when we look at the clock in terms of the 2-year discontinuance, we're really talking about, I guess, 2012, October.
We'll show the continued operations today, and we'll provide the law as well. My point basically is this. Mr. Lester raises Toys R Us and raises the level of business activity and the proof that was provided there. And here, he points to his sole cornerstone of his evidence as the affidavit of our owner. And so Department of Buildings basically correctly said that, okay, fine, we're going to discount that individual's testimony because the lawsuit that was taking place was for a collection of a debt. So we'll leave it to the board to judge the fact that when you talk about context, whether or not a person who is testifying as to business income would say, well, yeah, we didn't have any business income through that date. But that's the contextual question is the correct one to ask.
But why do you say that, that's something that you should provide us some reason or some basis for this conflicting testimony, don't you agree?
I don't
Instead of just
in the
leaving it to the
following
board?
I don't in the following respect. I basically
It just calls into credibility anything following.
that's fine, but the fact is that as of that testimony, what Department of Buildings did was they basically discounted all of his testimony. They said he's either lying in that affidavit or he's lying in the affidavit submitted to BSA. We're basically just not even going to look at those affidavits. And so when you remove those affidavits from the question, you still have business records, insurance records, phone records, and other affidavit testimony from parties who were unconnected to that lawsuit, including people who had been on the site for 5 days a week for an entire year, as well as the wife of the owner who did not testify in that hearing and basically provided evidence that she had been employed at the site for 2 to 3 days a week. So Department of Buildings correctly said, even if you discount that owner's testimony, they still carry the day with their submitted information and affidavits. And the issue here was really 280 bond. And so when we provided evidence to the board of 280 bond's activities, Mr. Lester was unable to point to that evidence and say why. Why would somebody provide business insurance? Why would they insure a property for millions of dollars for business activity, including, by the way, business income? Because there were items on that insurance contract which addressed business income, why they would insure that property for millions of dollars if there was no activity there. And the truth is, they wouldn't, because there was activity there. There was a filing at the DOB, not only as early as 1994, but continuing through to 2010, where there were over 400 permits filed for. The business activity that we allege, the plumbing and heating business, there is no other location that they have alleged that would have been appropriate for this owner to store materials, store trucks, dispatch individuals from. And as a matter of fact, there is no other, because when they allege basically that 8 West 28th Street, when they raised that address, they in their own testimony, in the testimony they provided, basically demonstrate that 8 West 28th Street was solely a mail drop. And I would just point to their testimony for a moment. The first testimony I would point to is from the deposition that, again, they provided to the board, which basically talks about West 28th Street and whether or not there was an active business location there, as well as whether or not there were trucks and other activities at the site. And what they say is, the $500 a month you pay for the lease of 8 West 28th Street, that's commercial space. Yes. Does that $500 include utilities? No. Who pays the utilities on top of that? He does. There is no utilities involved. I really only have a desk there. So this same testimony, which they are holding as a cornerstone of their case, basically contains the evidence that West 28th Street was solely used as a mail drop. And there's other testimony that provides that information as well. But I think most importantly, when considering 280 bond and the evidence they provided, Mr. Lester is required to be truthful to this board. When he signs his application for an appeals application, he signs the following statement. I hereby affirm that based upon information and belief, the above statements and the statements contained in the papers are true. Page 3 of Mr. Lester's submission discusses 280 Bond Street. It says, annexed hereto is a sworn deposition testimony in bold of Ivan Izakowicz, the purported proprietor of the plumbing business allegedly located at the site. And then basically he includes selected text from the deposition. And the first question is, do you run any business out of that address? And the answer is no. Leading this board to believe that he's referring to 280 Bond Street. And I know that Commissioner Opley-Brown yesterday raised this as a point, that there's direct testimony from the owner in the form of this deposition that nothing happened at 280 Bond. When you actually look at the deposition testimony, as far as where that quote is from on page 6 of the deposition, you see that Mr. Lester totally misrepresents the address here. The question at the time was, the address you gave us a few minutes ago is 976 East 10th Street. Is that your residence address? Yes. How long have you lived there? About 5 years. Do you live there with anyone else? Yeah, I live there with my wife. Do you run any business out of that address? No. The testimony that he provided with regards to 280 Bond, the statement from his papers didn't even refer to 280 Bond. It referred to 976 East 10th Street, which was a home address where he did not run his business. So we feel that this is a gross misrepresentation of what was actually in the record, is embarrassing, and basically is fraudulent and attempts to mislead the board with regards to what went on at 280 Bond Street. I would finally close at this point with saying that the listing in Exhibit E of the insurance solely lists 280 Bond as the plumbing address. And so we'll highlight that testimony for the board, but basically this is the only address that this business went from. When the board looks at the totality of the record here and looks at the insurance records that are provided, looks at the fact that 828 Street was merely a mail drop and a desk, looks at the fact that there are over 400 plumbing permits pulled during the relevant time frame, and all of the other testimony, we feel that the totality of that evidence provides extremely strong support for the fact that 280 Bond Street maintained a continuing business use during the relevant time, and that Mr. Lester's evidence to the contrary is solely Category D evidence of affidavit testimony, which is the worst type of evidence possible, whereas the relevant TPPN looks at Category A and B evidence, business records, city records, and that's what we've provided. He's unable to do so.
Questions for Mr. Lavelle? Commissioner Lebrun, do you want to comment on that?
No, I think he addressed my issue.
Okay, I just want to raise, I guess, a few concerns, or perhaps ask you to look further into some of the evidence. I think I commented yesterday, 2010 to 2012, I thought the evidence was somewhat sketchy. And I think the board may have a concern of not requiring a standard that was set by Toys R Us. And this is not a situation where this is a business that we're reaching back into time. We're not asking you to look at records from 1968. We're asking you to look at providing additional evidence, at least from 2010 to 2012. And I would agree with, on some points I may not agree with Mr. Lester regarding the percentage and what is considered substantially seized activity, and how Toys R Us relates to this particular site. But I think the type of evidence that would help support your case would be typical kinds of information that are related to a legitimate business. And if there was a legitimate business, I think they use the word legitimate in Toys R Us, I think you should try, and it may not be necessary to provide all that information, but perhaps information which goes along with any kind of business, which includes employee, customer records, sales receipts, and some of the others that were identified under Toys R Us.
That's fine, Madam Chair. We look
If there
forward.
was a business there till 2012, you should have some.
Sure. And I think part of the issue is, and part of it is the testimony of the financial advisor, which basically, in the course of the fact that there was litigation over customer receipts and over income, and much of this evidence was destroyed at the request of their financial professional. I mean, they really basically got rid of old records. That's what they did. So, but again, we'd be happy to provide additional.
Is that what happened? They got rid of
I
all
think
their
that they
business
did.
records?
I think that there was
because-
additional business records that they basically destroyed in the course of normal business practice. They asked their financial professional. They said, should we get rid of this evidence, and they did so.
All right, what about evidence that comes from the people that this business was working with? They didn't destroy their records.
We have additional information which we'll provide the board, and we will do so for past 2010. We'll provide that evidence to the board.
All right, I just want to have one other comment. I think what's not necessary to prove to us is whether this was a great business or a poor business. I have less concerns about the amount and intensity of the activities, so I think the fact that it should show whether you have 4 plumbing permits versus 15 permits, I don't think necessarily shows whether discontinuance. It just may show that the business wasn't doing as well in the later years. So that was just one comment regarding both the utility bills and some of the other activity that is on the site.
Well,
Commissioner?
I mean, also to add to that, it seems to me that if a warehouse is storage, then you possibly can prove that a warehouse continues to exist as commercial storage even if a business is floundering. So.
I would agree. Are there any other comments? Thank you, Mr. LaBelle.
Thank you, Madam Chair.
Mr. Durr, and then Mr. Lesser will bring you back and take testimony from your witnesses. Yes, Mr. Durr.
Good morning, Amanda Sturr, Department of Buildings. So as we just heard, this is not a simple case. We're receiving information from both sides, the complaining neighbors and the owner, and we're looking at and weighing, what is the evidence that might actually show discontinuance, and what is the evidence that is showing continuous use. So in this case, the affidavits, for all intents and purposes that they submitted to the board and to us, cancel each other out. I mean, you got one side saying there's no use, you have another side saying that there is use. So for all intents and purposes, those affidavits really cancel themselves out. So what we're left is the most persuasive evidence from the complaining neighbors is this deposition given to the district attorney's office in, I think it was February 2011, and there was another document as well in 2011. So when we looked at that, we also looked at what he said there, saying there's essentially no business for the past 3 years, I think is what he said. And when we looked at the actual permits that DOB issued, during that 3-year period, there were permits issued in 2008, 2009, and 2010. So it really doesn't square. So it's not so much that we are discrediting or even challenging the credibility of the statement to the DA's office, because it doesn't look like it is actually credible, to be honest with you. But we're weighing the actual evidence of what a government record, which shows that permits were actually pulled by this licensed plumber to do work. And when we do that, we can't come to the conclusion that this shows that there was actual discontinuance at the site when the government record itself shows that he was actually pulling permits. We don't know whether he actually did lie to the DA's office, if he did lie to the DA's office, what the explanation to that would be. But from the department's perspective, when we're seeing that permits are pulled and there's insurance records and phone records, we can't come to the conclusion that there's actually been a discontinuance during that 2-year period. So I think that might answer Commissioner Ali Brown's question about that you raised yesterday at the executive session. It's not that we're that the department is just discounting the credibility or lack thereof of an affidavit. It's the actual evidence itself, the government records, which show that he was still pulling permits.
Right, but couldn't you still pull permits even after you've ceased to use the site in Brooklyn? Because the permits weren't listing the Brooklyn site. So could he have continued to pull permits if he decided to almost like freelance and work here and there, select jobs that he could do without needing a storage warehouse?
That he might just pull permits for the sake of pulling permits
Well,
and
no,
not.
No, I'm not saying just for the sake of let me go pull some permits and never work on it, but is it possible that he could have pulled permits after ceasing to use that warehouse site because his business did fail?
I wouldn't say that it's not impossible that that's the case, but as we've heard, he and I think both sides agree that this Manhattan office was just a office used for his desk and clerical work or whatever, and all his storage of materials was at 280 Bond Street, and we have photographs showing the satellite pictures showing trucks there. We have his insurance records that he submitted. I mean, honestly, yes, we would like more information from the owner, but what we have so far from the complaining neighbors hasn't been enough to actually show that the use discontinued. So it's not an easy position for the department to be in where we're weighing this evidence on both sides. But at this point, we just don't see enough evidence to show that the use is discontinued.
Okay, so so what you're saying is in terms of what the appellants have put forward, which is mostly affidavits, that's been canceled out, and this other issue which has to do with the deposition, and you're saying that also essentially cancels itself out because there's other factual evidence in the record, which is government records, including these permits, that overrides that.
I'd say that's a fair assessment, yes.
All right. Any other questions for DOB? Mr. Durr? Okay, thank you. Mr. Lester? Would you like to respond back and then
Yes.
call up your witnesses? Okay.
Of course. I think I was accused of misleading this board, and of course, I take strenuous objection to that. We were very careful in our submission, to submit the entire deposition. We didn't submit excerpts, we didn't paraphrase, we didn't take it out of context. The entire deposition, the entire transcript was given to the board. So if there's any misleading, the misleading was in the testimony in the transcript. If there was an intention to mislead anyone, it was coming from the mouth of the witness in that proceeding. But we submitted the entire transcript. Now, certainly, as an advocate, I have a right to draw conclusions from what I'm reading, just as you will draw conclusions. And he was clear to say that he did no business. He didn't mention 280 Bond Street, so if he had done business at 280 Bond Street, he certainly would have mentioned it. So there was testimony. He was very clear that he had not done business in the 3 years prior to that deposition, which was 2011. Now, as it pertains to the permit that he pulled at Beach 100th Street, I think there's a very simple answer to that. There would have been a general contractor on that job. He was the plumber, supposedly. I mean, he may have done the work, or someone else. He could have hired someone else to do the work under his license. We don't know. But there had to have been a general contractor who was at the site who would know where the plumbing supplies were coming from. Was it coming from 280 Bond Street? Was it coming from someplace else? I mean, there would be available witnesses. I think if the Department of Buildings had done due diligence initially, and we could do that now, we could try to locate that general contractor. We could subpoena him. He could come in, testify under oath. Where did the work originate? If that's the only proof of any business in 2010, and 2010 becomes the determining factor, then it's important to know what the context of that job was. He wasn't the plumber wasn't the only one at the site. So I think that would answer that. And in terms of the insurance, yes, we concede he had insurance at the building. But if he was a licensed plumber, wouldn't he have professional liability insurance or some insurance connected to his practice? And
So
certainly
you
not.
were saying that the way the insurance, so it's on the property versus the actual
Right.
insurance on the
I mean,
business?
he may have insured loss of business. You could insure loss of business if you're not doing business. But if he was actively carrying out his trade, wouldn't he have liability insurance? Question. And I think that would be relevant as well. But we do have other witnesses here, and I want to start with Brenda Bello will testify first, the registered architect.
All right, each person will be given 3 minutes.
Good morning. My name is Brenda Bello, and I'm a New York State licensed architect. I've been practicing for 20 years. I'm fairly familiar with the building department permitting processes and other administrative things. I wanted to say something about the actual permits being evidence of use at 280 Bond Street. I think that the question has already been raised, but permits issued by the department do not have anything to do with where the work is happening from. There are two things that are factual. One is the project location where the permit is for, and the other is the licensee who's applying for the permit. Those two things are fact. Aside from that, the mailing address is never verified, and certainly the working address is never verified. For a plumbing business, the Department of Buildings allows a mailing address so that they can get in touch with the business, but you can have your shop, your warehouse, anywhere outside of the 5 boroughs. The office has to be within the 5 boroughs, and I would like to call into question why this 8 West 28th Street address ever existed if there were people at 280 Bond Street 5 days a week. And also to say that, as Ms. Ackerman said, that for administrative reasons, the office had to be in Manhattan. That is clearly not the case. I think that's all I have to say about that. Thank you.
Thank you. The next speaker.
Good morning. My name is Emily Poisson. I live on 476 de Gros Street. So I'm the house right abutting 280 Bond Street, and I'm here to actually invite you on site and see by yourself what is happening there. Because I know, like everybody seems to say that the affidavit don't weigh in, but they have been saying all along that there were trucks leaving at 6:30 a.m. loading plumbing supply. Well, please. Come to my living room and come to my bedroom that is actually right above their parking lot and come and see if I would not have heard plumbing supplies being loaded to trucks at 6:30 a.m. I actually bought that house in February 2011 and I never heard one truck or plumbing movement at all. I was even at home from December 11 to May 2012 on maternity leave, and I heard nothing during the day also. So I just, I'm inviting you, since there's been, they say, we say, whatever, please come and see by yourself, and you will see there is no way whatsoever that they could have loaded trucks at 6:30 a.m. without us noticing. The other thing that I just wanted to point out, because I'm not a lawyer, but I'm just looking at the facts, and everything that the owner has just stops in 2009. Even the Con Edison bills that were mentioned earlier for $60 or less, which is not even what we pay for a house of 4 people a month, stopped in 2009. There is no Con Edison bill past 2009. And the Verizon bill that they submitted doesn't mention 280 Bond Street at all. The bill actually states the address on 10th Street. So I don't even know why this is relevant to that case. Again, I'm sorry I'm not a lawyer, but I'm just looking at the facts and everything. Their employee testimony stops in 2009 or 10, I'm not sure anymore. Their tax accountant said it stopped filing in 2009. If he stopped doing the files in stopped filing in 2010, that means he filed for business in 2009. I mean, it's very hard for us to prove zero because, we don't have concrete of zero, but everything stops in 2009 at this point, and I just wanted to state the obvious. Thank you, and please you're welcome to my house.
Thank you. The next speaker.
Good morning.
My name is Katya Justin. I'm one of the appellants in this matter, and I appreciate the opportunity to speak to you. I live at 472 DeGraw Street, which is 3 doors down from the site in question. I have carefully reviewed the transcript from the last proceeding. I wasn't able to attend. And I noted that, Madam Chairwoman, you said that there were, quote, a lot of areas that made the board uncomfortable with the evidence that had been submitted by the owner in his efforts to refute the discontinuance of nonconforming use at 280 Bond. Specifically, this board asked to see employee records for the purported 10 employees Ms. Ackerman testified were employed there. But no employee records have been produced. No timesheets, no payroll records, nothing. Ms. Ackerman testified that there were 4 phones at the location. Where are the phone records? All that has been produced is an email purported to be from a Verizon employee and a phone bill that lists a different address for a Manhattan location that states that it has call forwarding to an unspecified location. How is that relevant? Ms. Ackerman also said that they used to pay over $1,000 in different bills, Verizon, Con Edison, Brooklyn Union. Where are the records? The utility companies would have them. Not produced. The only thing that was produced were a smattering of records that span approximately 1 year in 2009, and for the most part show minimal use, not the use of an active ongoing business. They claim they were running an active business from the 1980s to 2012. Where are the records? We have these DOB permits, and as Ms. Bello said, they list the Manhattan address. Where is the connection to 280 Bond? It's just not there. We don't even know if Mr. Ozakowicz was actually doing the work. Where's Mr. Ozakowicz? Where is he? Is he here? I don't see him here. Respectfully, what we have instead of records are 2 affidavits from 2 interested parties, Mr. Ozakowicz and Ms. Ackerman. And when we have had the opportunity to test their assertions under oath, we have established those assertions to be false, time and time again. The board at the last hearing asked Ms. Ackerman about the office at 28th Street in Manhattan, and she testified that there was an office there. But we have submitted a sworn-to affidavit from a completely disinterested party that there was no office there. They used it for mail, a mail drop. Why? Because there was no one at 280 Bond. And in fact, Ms. Poisson sent this letter to Mr. Ozakowicz as we put in an affidavit before you in an effort to get into the property to fix a wall that the 2 properties share, was returned to sender. And we have that for you. Why? Because there was nobody there. And focusing on the issue of veracity for a moment, we have our opponent's lawyer calling into question the veracity of our counsel, and I find that rich. I find it offensive. Veracity intersects with the weight that certain evidence should be given. And the weight of the evidence is critical here. And as we have established to this board, and this was Exhibit J to our first submission.
I'm sorry, your time is already up. Could you just conclude your statement and provide it in writing? Yes, you can.
Thank you, I appreciate it. Exhibit J to appellant's first submission, the owner, Mr. Ozakowicz, was convicted of tax fraud in a criminal case in New York Supreme Court in 2011. He was prosecuted for this. He pled guilty to an E felony. And you may be wondering why I raised this to you. And I submit that this is critical. When assigning the weight to evidence presented to you, the board should consider his affidavit sworn to and submitted in connection with that criminal case as having a tremendous amount of weight. This affidavit was submitted as Exhibit H to our March 11th filing. As our lawyer mentioned to you, I used to be an ADA. I was an assistant U.S. attorney, and I submit that an affidavit submitted by a criminal defendant in a criminal prosecution brings with it very high stakes. When you file an affidavit with the district attorney's office, when Mr. Ozakowicz filed this affidavit, he put his liberty interest at risk. If the district attorney thought that he was lying and could establish that he was lying, he could go to jail. And these forms are typically filed with advice of counsel. And it appears that this form was filed with advice of counsel. You can see at the bottom, it was faxed by his lawyer to the DA's office, and we received it from the DA's office from their file.
In the affidavit, he states the name of his business, Excellence in Plumbing, and this was in 2011, and says he has no business, no employees. And this is corroborated by scores of affidavits from us that should be given weight. They are credible. But also from parties with zero interest in the outcome, corroborated by his own sworn testimony, Mr. Ozakowicz's own sworn testimony and deposition, and corroborated by the absolute failure to produce any evidence of an ongoing business. No tax rolls, no employee records, no paychecks, nothing. No invoices, bills of lading, nothing. Evidence that I submit wasn't presented because it simply doesn't exist. We also we have an affidavit for you from a prior tenant who used to live in the Poisson's house. He no longer lives there. He has no interest in the outcome of this proceeding. And what does he say? He heard no business. He heard no trucks leaving at 6:30. He heard no plumbing supplies being loaded. What did he observe? Homeless men scaling the wall to get into the property, presumably in search of shelter. Why? Because it was vacant. So the weight of the evidence is in the appellant's favor. And I just want to say one more thing, and this is more of a personal note. Many of us are here. We live in a very quiet residential part of Brooklyn, on a block where many of us purchased our homes long ago when they were affordable. And most of us have sunk our life savings. I myself was a public servant. We've sunk our life savings into our home. It is a quiet, residential, tree-lined block where we are raising our children.
I'm sorry, your time is up. Thank you.
We very much appreciate your attention to this issue. Thank you.
Thank you. The next speaker? Are there any more speakers? All right. Do you want to add anything else to the record? We'll ask the buildings department and the owner if they want to add anything else into the record right now. Yes. Mr. LaBelle, do you want to respond back? Okay. And then we'll set a schedule.
To say that there are third-party affidavits against our testimony which have no interest in the proceedings is a complete overstatement. Obviously, there are affidavits on both sides. In fact, we have testimony from people who had former business relationships with the owner here, who used to visit the property for the course of a decade, who clearly have no interest in the proceedings. So obviously, there's evidence on both sides weighing in here. The problem is that while Ms. Jestin talks about the weight to be given to that affidavit and that deposition, the truth is that as far as our world is concerned, and as far as the Department of Buildings is concerned, it's the worst kind of evidence. And so when we give you positive evidence here, that's the best kind of evidence. And the city records that we give are the best kind of evidence. And so if you cancel out our affidavits and their affidavits, we still have sufficient proof showing that there was an operating business at this time, and they have not been able to give us testimony as far as where the business that is alleged, which is the storage of this plumbing and heating material, really, and that's what's on the C of O, took place. They haven't said that this man was storing these materials at West 28th Street because they know that would be idiocy, and they haven't said that he's storing it at East 10th Street because it's a residential home. That is what we feel is compelling evidence and is definitive here. Thank you.
Yes.
Wouldn't very good evidence of the existence of the business be testimony here before us from the people who actually ran the business, Mr. Osakowicz and Ms. Ackerman?
We'd be happy to have Ms. Ackerman come back.
What about Mr. Osakowicz?
Mr. Osakowicz, to the extent he's medically able, we would have him come. He has been on dialysis and has had medical issues which have prevented him from coming in to testify. But to the extent that we're able to bring him in, we'd be happy to bring him in. Mr. Lester asked us to depose those people. Ms. Ackerman has come and would come again of her own free will. I mean, the truth is that you're operating a plumbing business in New York City. There's going to be some good records of that, and there's going to be some sparse records, and she can testify as to why they can't produce what they can't produce. It's not necessarily that it didn't happen. What's more likely is that sometimes a plumbing business doesn't have good records. There's various reasons for that, and she can address that.
I understand sloppy record keeping for a small business, but we're talking about a time period here where there were claimed to have been employees.
And we
I'm
have
not seeing any employees.
we have an affidavit from the foreman, from Seth Nahum.
But no records.
We to the extent that we can have Ms. Ackerman testify as to why there are no records, we can do that.
It's troubling.
We believe me, it's been a tremendous amount of effort on our part to get what we can get. And we've really, the issue that we have is that we look at the categories of evidence, and there's good evidence on our side, and there's no category A or B evidence on their side, none.
Any other questions? All right, I think what would be helpful for the record is there's a lot of confusion, or some confusion, about the connection between West 28th Street, I guess 8 West 28th Street,
Sure.
and 280 Bond. I think it'd be helpful to the record if you just go back to all the evidence that you have and sort of identify to us that connection.
Sure.
And the records that speak to it. So there's evidence of record clearly that seems that both parties agree that 8 West 28th Street is a small office at best, and really they weren't storing anything over there.
Correct.
But I think the connection to 280 Bond, there's a lot of evidence here. I'm just trying to put that all together
Sure.
again. So if that connection is made more easily and I guess where we can see it very clearly, then I think other issues that have been raised regarding the permits and whether the permits association with 280 Bond become much more clear.
Okay.
So, so I think you want to really establish that again for us. We'll give you more time. You said you'll try and provide more evidence.
Absolutely. We already have additional
think
evidence that we've received. We've submitted Freedom of Information requests and have gotten evidence in since the time of our last submission, which we'd be happy to submit.
Okay. All right. If any more comments? Buildings Department, no. Mr. Lester, do you have anything to add in the record? Otherwise, we can set a schedule.
The only thing I would
yes.
say, in summary, behind what Ms. Justin said, Mr. Lobel is saying that this, and also the Department of Buildings, has set this up as a contest between what we submit and what they submit. And I think if the board goes back and looks at the resolution in the Toys R Us case and the record, which I did over the weekend, what the board felt in that case was the lack of evidence was determinative, because you can't prove a negative. You can't prove, the Sherlock Holmes saying that the dog didn't bark. It's very hard to prove a negative. But when there's an affirmative duty, because the statute says active operation. It uses the word active and it uses the word substantial. So that means, because it's not a complete cessation standard, that means the burden is on the business owner to come forward and, Madam Chair, you said the right word, legitimate. Come forward with evidence of a legitimate business. The fact that there may have been plumbing supplies lying around doesn't make it a storage. I mean, in the Toys R Us case.
But, sorry, go ahead.
I'm sorry.
Well, I think that there is something about which is contextualized, the different kinds of business, and then how the space is used depends on the business.
Right.
It's very, if this was, I don't know, a startup company, it would have desks and many people with computers at their table,
Right.
probably have huge electricity bills. This was supposed to be a location where they put their plumbing equipment, and it was dispatched, and I guess, I don't know, a few times a day, or it depends on how many permits they had, to other locations.
Right.
So that was the area where I thought you cannot really analogize what happened at Toys R Us to this particular site that easily. I think, well, we also had a chance, at least counsel and myself, had a chance to go back and look at the
Right.
Toys R Us record this weekend, and I think the issue of lack of evidence, one thing, but it also seemed that the evidence that was provided actually showed that there was very little activity. So they did rely on that evidence to show that they had records, but they showed one iota of what was the
Right.
full extent of the accounts over there.
What-
And similarly, in terms of the space, I think those issues are not relevant over here. The space issue is it's a completely different story.
Right. What tipped the balance there was, again, I go back to that point, the BSA actually subpoenaed, I think there were 3 or 4 witnesses that were put under oath in the final hearing because there was conflicting evidence. And here the conflict is from the individual himself. I mean, yes, we're saying one thing and the owner is saying something else. But the owner is saying contradictory things.
Yes,
So
we
I don't know how we come to a resolution if Mr. Sakowitz is not produced. He may be ill. I don't know what his circumstance, but certainly an inference can be drawn from a missing witness. That's black letter law. If the witness does not, and I'll produce it the next year, if a witness who has relevant material is not produced, an inference can be drawn. Now, if he has a medical condition, that's something that could be verified. But the failure to produce the one witness who seems to hold the key to this whole puzzle, the failure to produce that witness speaks volumes.
Right, but the only thing I would say is to prove either continuance or no two-year discontinuance, the board doesn't have to rely on witnesses. The board can rely on records.
Right, but again,
So I would just say that is not the critical part of this.
it may not, but in that case, witnesses were crucial, and I think witness is crucial here, too.
All right. Thank you, Mr. Lester. Any questions? All right. Mr. Lobel, you don't need to respond to that right now. We're going to set a schedule. I know you. Okay, let's set a schedule. So we think it's helpful if, as the owner, you should go first and provide additional evidence. As you know, we said there were some areas and years that were sketchy. We've asked you to explain the reasons for any conflict, supporting evidence about the relationship of this business at these locations, more clarification on the insurance policy, and I'm sure you can read the transcripts. There were a few things we wanted you to do. So how much time do you need?
I think we'd ask for a minimum of 4 weeks.
All right, 4 weeks. That would be April 29th. Just thinking, probably the buildings department should go next. Okay, look at both sides. All right, that seems fine. And Mr. Lester, you don't have an issue with that. So if you can respond back on, let's see. Do you think you could respond back in a week for that?
That would be,
Well, there are two issues. One is during this month, you could actually put
Right.
additional information which
got
you
2
want to
weeks.
talk about. And if you have a week, because otherwise we'll be going all the way into June, so I'm trying to put this on in May. So if you can respond back on May 6th and the Buildings Department on May 13th, we can have the next hearing on May 20th. Okay?
thank you.
All right. Yes.
Zoning calendar, decision items, item number 1. Calendar number 9413BZ, 11-11 40th Avenue, Queens, Vinod Tawan.
Good morning, Leandro La Chica for the applicant.
Okay. Just give me 1 minute. Motion to grant?
Chair Srinivasan.
Aye.
Vice Chair Collins. Aye. Commissioner Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
Item number 2, calendar number 10313BZ, 81 Jefferson Street, Brooklyn, Rothkrug, Inspector.
Good morning, Todd Dale for the applicant.
All right, we'll defer the decision to May 6th.
May 6th?
Yes.
Item number 3, calendar number 2, 8113BZ, 350 through 370 Canal Street, Manhattan, Warsaw, Bernstein.
Good morning, Josh Reinsmith for the applicant.
Motion to grant?
Chair Srinivasan.
Aye.
Vice Chair Collins. Aye. Commissioner Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
Thank you very much.
Item number 4, calendar number 29113BZ, 842 Lefferts Avenue, Brooklyn, Eric Palatnik.
Hello, good morning, Eric Palatnik.
Motion to grant?
Chair Srinivasan.
Aye.
Vice Chair Collins. Aye. Commissioner Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
Thank you.
Continued hearings, item number 5, calendar number 13013BZ, 1590 Nostrand Avenue, Brooklyn, Rothkrug, Inspector.
Good morning, Todd Dale for the applicant. From review session, I understand there was a little confusion regarding the parking study and the number of spaces shown on the plan. Just to clarify, the parking study is accurate that there were 40 accessory spaces provided. In the statement, we note the 35 the accessory spaces in reference to that those are the spaces that are in the lot that were designed to be used by the customers in the store. But the statement also references the fact that there is going to be employee parking. At one of the previous hearings, the board had noted that the 5 accessory spaces to the side that were by the loading dock should be reserved for employees. So that's where the discrepancy came up as far as the statement. But there
Okay,
are
so-
40 spaces provided, and
But
it's
that
just...
includes the employees, and the demand was only, that you looked at was for the customers?
Well, no, looked at the demand.
for
I mean,
both, right?
Regardless of 40 or 35, if I recall the study correctly, they said that they're expecting that the number of spaces that would be required would be 35 or 36.
Right.
And then the
But that's
analysis,
that includes both employee and customers, correct?
that includes, yes.
Because it's based on a calculation, right?
Yes,
Not
yes,
the
the
square
35 and
footage.
36, yes, that includes all that. And that would be satisfied by the available on-street parking in addition to the accessory parking, so more than enough.
Right, in fact, it would be able to be accommodated just by the accessory parking.
Correct.
Okay. That's been clarified?
Yep.
Okay,
I
good.
get it now.
All
Thank
right,
you.
are there any speakers on this item? Any other questions? All right, I made one note about the portion of the building that's at the rear, and I think you should just limit that right now to use Group 16 warehouse because it hasn't been analyzed, and you're not proposing right now to use it for retail.
Okay, understood.
Okay, so if you could just modify your drawings. Okay, so I think we can close the hearing. If you can submit to us on April 15th, we can vote this out on April 29th.
April 20?
29th.
Okay, thank you.
Motion to close.
Chair Srinivasan?
Aye.
Vice Chair Collins?
Aye.
Commissioner Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Ali Brown?
Aye.
Item number 6, calendar number 17913BZ, 933 through 939 East 24th Street, Brooklyn, the law office of Frederick A. Becker.
Good morning, Lear J. Altman from the law office of Frederick A. Becker.
Any questions for the applicant on East 24th Street? Any speakers on this item? No speakers, we can close the hearing.
Thank you.
Chair Srinivasan?
Aye.
Vice Chair Collins? Aye. Commissioner Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Ali Brown?
Aye.
We'll decide this on April 29th.
Would it be possible to have a decision next week by any chance?
We'll have it on April 29th.
Understood.
Item number 7, calendar number 25213BZ, 1221 East 22nd Street, Brooklyn, the law office of Frederick A. Becker.
Good morning, Lear J. Altman from the law office of Frederick A. Becker. We did attend your executive session and heard your comments. We are prepared to address them. First, regarding the canopy, we have already had the architect revise the plans. The canopy is shown in dashed line on every page now, and a note has been added on every page that shows the canopy, saying that the canopy is subject to DOB approval.
Okay.
Thank you.
Regarding the adjacent height, that was actually measured by the architect.
That doesn't,
I believe that was the question, how was
yes,
it
there
determined?
was a question, but I think measured by the architect, but yes, Commissioner Montanez?
Right. Basically, your neighborhood character that to justify this FAR and building height is based upon a building across the street, which had a special permit, a building around the corner where the data comes from Oasis, and a building 2 doors down. And in looking at other available data, I just questioned the FAR and the building height. For example, the one you're using for the building height is a pre-existing building from, I think, constructed in 1950 on a much smaller lot, which has an FAR of about .63.
But the height, nonetheless, is as tall as this building and does give the same appearance as far as height is concerned.
But the building across the street, which has the special permit, is on a much smaller lot, and that has a building height of 35. And there are 2 other buildings in your streetscape. I believe it's 1239 and 1245, which also have special permits, and their building heights are at 35 feet. So I just had the feeling that the information was a bit cherry-picked.
Well, the reality of the situation is that every building is unique and it stands on its own. What we did was we looked at the other heights in the area to see that this height wouldn't be out of character with the area. And based on the fact that the home 2 houses to the left is as tall as this building is being proposed, we felt that this height would fit within the character of the neighborhood.
Well, in terms of bulk, it's both FAR and height.
Correct. And again, the FAR falls within what has previously been granted on this block by this board.
Right, but there are other buildings that have been granted special permits which have a slightly lower FAR and lower height.
Correct. Well,
which
those
I think
homeowners
are-
may have chosen to request a smaller height and a smaller FAR.
But I think if you look at the neighborhood character, those buildings would also be included.
Of course they would, but it doesn't take away from the fact that there are other larger homes on the block.
Well, this particular home is on an extremely large lot, so the bulk is really much bigger in terms of its impact.
Yes and no.
Well, yes, it is, because it is a larger building and much larger than the others. And I would just say that the one project that you referred to, which is 1.08 FAR, is in fact on a much smaller lot. So it seems to me that we can have, back and forth on this, but instead, it seems there are some changes that you could make, which would, I think, satisfy all the commissioners.
What changes is your board suggesting? Is that regarding those double height spaces?
Double height spaces and perhaps bringing the height of the building down.
What I'd actually like to discuss with you is that double height space. That double height space is actually, if you were to look at the building, the area that is under the edge of the slope of the roof. What the client and the architect had chosen to do was to remove the floor that would have been there and benefit from that space that otherwise would have been excluded from floor area anyway, because it is low in ceiling height if the floor is there.
I'm not understanding. I know it's at the edges, but...
Exactly, at the edge of the
So
building.
you're not going to put a floor there?
That's basically what's happening, is they're not putting the floor here. If the floor were here,
Yes.
in that double height space, it still wouldn't be included in floor area.
Right.
Because the height
I understand
is
that.
so low.
But why
So
are
it-
you not putting a floor there?
to benefit from the additional height in the bedrooms below. The thought was at least they could benefit and get
But
some
it's-
additional light in the rooms. That was the purpose of that double height space. If
Is
you'd
the
like-
light coming, where's the light coming from?
If you look at the windows layout, you would see on the elevations, there's actually high windows to benefit
In those
from.
portions?
Correct.
Okay, and even in the
On all four of
the
those portions,
restroom?
yes. But as I said, this is not space that would have otherwise been included in floor area. So it is not actually changing anything by taking out those floors. It is just providing a benefit to the client without changing the building.
Okay, and what about the overall height of the building?
The overall height of the building, I would have to speak with the client, and I'd have to speak with the architect before making that determination.
Okay. That would be good. Any other questions? Any speakers on this item? Oh, we can bring you back on April 29th. So if you submit to us on April 15th, you can have the hearing on April 29th. All right, if we're satisfied, we could consider, since it's been a back and forth, a little bit of back and forth.
I very much appreciate that, and I know the client and the architect do as well.
But if we're not satisfied, it may just go on.
Of course.
All right. Okay, so we'll continue the hearing on April 29th.
Thank you.
Item number 8, 270-13BZ, 288 Dover Street, Brooklyn, the office of Eric Palatnik.
Hello, good morning, Eric Palatnik.
Any questions for the applicant? No. Any speakers on this item? Speakers? All right, we'll close the hearing.
Chair Srinivasan.
Aye.
Vice Chair Collins.
Aye.
Commissioner Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Otley Brown.
Aye.
We'll decide this on April 29th.
Thank you.
Item number 9, 273-13BZ, 321 East 60th Street, Manhattan, the office of Ackerman Centerfit.
Good morning, Madam Chairperson and Commissioners. A representative from our office attended the board's executive session yesterday. I believe that Commissioner Collins had a question related to the proposed nine parking spaces on the building's first floor. As we indicated in our prior submission, the spaces will be offered to the residents of the building first. However, we just wanted to note that any unclaimed spaces would be made available for public use as permitted by Section 1321. We also wanted to note, for the purposes of putting together the economic analysis, the spaces were considered income-generated public parking spaces in order to be conservative.
Thank you.
But it is basically accessory parking, and if it can be rented out, it's only under the accessory parking rules. Is that correct?
Correct.
You're not asking for, maybe, but I don't believe you're asking for use group 8 at that level.
In other words, if they can't be used by the residents of the building, at that point, they then would be offered to people outside of the building.
Right, and that is allowed under the zoning for any residential accessory parking?
Correct. Specifically, in this case, pursuant to Section 1321. But if you want, we can provide that to the board in writing.
Okay.
Additionally, I believe that you had a request that we should remove a certain added construction cost related to the construction fence and plaza from our analysis.
Right, because I looked at this site, and honestly, I couldn't see how the construction fence really was much, somehow it was some kind of hardship to have a slightly longer construction fence or doing a little bit of paving on that little triangular corner.
So we'll remove that and make the adjustments accordingly. And lastly, I think there was a request for additional information related to the construction staging method. So for the board's convenience, we'll also provide that in writing.
Right, if you could just explain to it. So there are not going to be any cranes. There's going to put, I don't know where they're going to put the equipment, but it changes my understanding, the method of construction of the building itself, right? From heavier masonry or construction.
We'll ask the general contractor and the architect to provide a detailed letter for you.
That'd be great.
And so if there's nothing further, what I'd like to request is possibly to close the hearing, but leave the record open for receipt of the sign-off from the Department of Environmental Protection.
Does the board have any concerns about closing the hearing today?
No.
Okay, good. You have to get a sign-off from DEP, and you're going to submit to us a revision. With these adjustments to the premium costs, can you reflect that also in your statement of facts and findings as well? And if it affects your financials, to take a look at that as well? Okay.
Yes.
All right, so why don't you make your submission? I'm not sure I asked. Are there any speakers on this item? Any speakers? Okay. Why didn't you make your submission to us on April 22nd? That's about 3 weeks from now, that's okay?
Okay.
Okay, and we can set the decision date for May 6th, pending DEP sign-off.
Thank you very much.
Motion to close.
Chair Srinivasan.
Aye.
Vice Chair Collins.
Aye.
Commissioner Hinkson.
Aye.
Commissioner Montanez.
Aye.
Commissioner Ali Brown.
Aye.
New cases, item number 10, calendar number 17813BZ, 21-41 Mott Avenue, Queens, Gonzalez, Sago, and Harn.
Jeffrey Chester for the applicant. Good morning, Commissioners. This is a application to reestablish a special permit which expired in 2011. The McDonald's restaurant has been there in the Far Rockaway neighborhood since 1974, and the special permit for the drive-through was first granted in 1994. I was at executive session yesterday, and I know there are a couple of issues that came up, so I'll try to address them accordingly.
Yes, do you want to?
I didn't know if there was,
them?
ones that were particularly more
No, I think
concerned than
that's
the others.
fine. I know there was an issue about signage.
Yeah, that's right, and I did look at that, and it does seem that that is not possibly accurate, the 40 square feet cumulatively. I spoke to the architect about it yesterday when I returned to my office, and they're going to look at it closely again and make sure it's accurate. So we'll get that updated as quickly as possible. I don't know. It doesn't make sense to me either, quite frankly.
Okay. And the second question had to do with the operation of, since this is an overnight, 24-hour operation.
It is a 24-hour operation. The drive-through alone, the store closes at a certain point. I have the owner here. He could actually speak to that. And then there's drive-through. I spoke to the owner about it. He said that, in terms of volume, on a weeknight, they do about $300 worth of business. That's how they look at it. And on a weekend night, maybe about $500. I asked him if he could translate that into actual car trips. He said, depending, it's like 5 to 10 cars per hour.
Throughout the night?
Yeah. But,
More volume than I thought, but.
But you realize, that I don't know how long each car is in the drive-through, the 2-3 minutes, and then they're gone. So.
Okay, I know Commissioner Otley Brown had a question about that.
Right, that was my question. I just wanted to get an idea of the volume of traffic that's going to go through the drive-through since it's adjacent to residential.
Right, and by the way, I do think it's important to make the point that, as I did at the beginning, that the drive-through's been there since 1994. We've lived with those adjacent residents since 1994. Because we filed this on a BZ notification, they all just got notification again of the hearing. The current operator, who's sitting here, has owned this location since 2000 and has never once received a complaint about noise or any other concerning externalities from any of the residential neighbors.
I just have a related question. When they do use the drive-through, do they just exit the property afterwards because the restaurant is closed, or are they allowed to stay on the property and utilize those parking spots that are to the right of the lot?
I don't know the answer to that, but if Mr. Lorino wants to come up, Gerald? This is Gerald Lorino, Lorino Enterprises, who's the owner of the location.
95% of the customers leave. They get their food and go. They're on the run, going to work, from work. So they get their food and go. Very, very rarely do I see someone park after they've used the drive-through.
Yeah, my concern is just the parking that is front in along the lot line.
On the east side, next to the building, the liquor store there?
That's a liquor store? Because I'm looking at the plot plan and I couldn't tell what was next.
The only
Is that a
building-
liquor store on Mott Avenue? What's on Mott Avenue directly adjacent?
The liquor store.
That's a liquor store?
Right.
Yeah.
Okay, then I have no problem.
Okay, and just on the other side, actually on Beach Channel, adjacent to is the residential, correct? Okay, I think it'd be helpful if you could just provide us a photograph of that lot line condition.
Well, actually,
And, because I'm looking at the drawing, it says planting area. I don't know if there's a fence there or is there a wall?
if you take a look at photograph 3, which was in the initial application, you actually see a piece of just a piece, mind you, of
Right, well,
that fence.
That's exactly, I know, I looked at the photographs and I thought it wasn't very easily, I couldn't really see it properly, so. can
So
you
there
just
there
pro-
is a
There's a
chain link fence with wood slats.
Okay.
And directly adjacent to the chain link fence, on our side of the property, there's shrubbery. So
Right.
the shrubbery, then a chain link fence with wood slats.
Well, if you can just give us a photograph, just photographing that lot line condition, as well as reflect that on your drawings,
Okay.
so that we understand that that's where the buffering is taking place, and just detail that out. That'd be helpful. I'm looking at the drawing, and it seems that with this kind of volume, which is, I guess, 5 to 10 cars an hour, right? I think the likelihood is that you probably are not going to find any queuing taking place, right? Most of the cars will just actually be able to drive up all the way to the window.
Right.
At the most, it seems like there may be 2 or 3, and so at least they won't be lined alongside of the residential at night, so that's a good thing.
Correct. That's correct.
Okay, so if you can provide that to us as well as the signage, we can bring you back.
Okay.
Okay, are there any other questions for the applicant or the owner? All right, thank you. Any speakers on this item? Okay, there's no speakers. So, Ms. Chester, if you can submit to us on April 22nd, we'll continue the hearing on May 6th.
Okay, thank you.
Item number 11, calendar number 25013BZ, 3555 White Plains Road, The Bronx, Warsaw, Bernstein.
Good afternoon, Josh Rhinesmith again for the applicant. This is an application for a special permit under 7336 to permit the operation of a fitness center within a new building that's being constructed at the premises. From yesterday's executive session, I understand the board had some questions about the split lot condition as well as the status of the DOB approval. The property has dimensions of 111 to 116 feet deep from White Plains Road. The C24 zoning district is mapped to a depth of 100 feet. So anywhere from 11 to 16 feet is located within the residential zoning district. The district boundary is essentially allowed to be relocated to the rear lot line pursuant to 7711 because it's less than 25 feet from the district boundary to the rear lot line. If it was greater than 25 feet, then we would require a special permit in order to extend into the residential district. With respect to the DOB approval, this application was originally filed with the PCE use and then was subsequently amended once we obtained the objection to file at BSA to remove the PCEU so they could begin working through the Department of Buildings application and obtain their permits. I've been told that all objections have been removed. From a DOB perspective, the only thing we're waiting for is sign off from MTA due to the site's location immediately adjacent to the elevated subway.
Can you provide us with the DOB drawings and the zoning calculations on that?
Yeah, I can.
I think that will reflect the 7711.
It should.
Which, ultimately DOB has to approve. We're agnostic on that. And also, I think it'll just, it'll confirm to us that the space that the PCE is occupying is essentially commercial space of similar parking categories. So if you could provide that to us, it'd be helpful.
Certainly, I can do
So
that.
the permit has got approval, but the only thing required,
Well,
I thought construction has already started.
no, not on this location.
Okay,
It's,
so what's that frame structure that's shown in the photographs?
I'll have
Right?
to take a look
Yeah,
at that.
I thought there's framework, like a steel frame.
I'll inquire. I
Okay.
thought it was a vacant lot in the pictures.
Right, the photographs, I think, show the steel frame, so at least that's what identified as the site, so it's a little bit confusing.
Yeah, in person.
I'll clarify.
Okay, if you could just take a look at that. Okay. Any other questions for the applicant? Any speakers? Okay. We'll continue the hearing. If you can submit at April 22nd, we'll continue the hearing on May 6th.
Thank you.
Item number 12, calendar number 27513BZ, 404 through 406 Broadway, Manhattan, Warsaw, Bernstein.
Josh Rhinesmith for the applicant. This is a special permit application pursuant to 7336 to permit the operation of a small yoga studio on the third floor of a building located on the east side of Broadway, just south of Canal Street. I understand there were a few questions that the board had. First off was the rear yard compliance with respect to the addition being made by the property owner. If you look on the site plan that was submitted, right at the top, it shows a measurement showing that a portion of the zoning lot is within 100 feet of the corner of the intersection between Broadway and Walker Street. And because it's within 100 feet, there is no rear yard requirement. There's a small portion of the lot which is not within 100 feet, which is actually providing the required rear yard. The addition is not in that area.
Has this been reviewed by DOB?
Yes, it has. And there is a stop work order on the property. That was originally issued for the entire building due to some egress issues. However, the architect informed me that all objections with respect to egress have been satisfied, and all that's really holding up the rescinding of the stop work order is is paperwork. However, we had obtained a partial rescind of the stop work order to allow work to occur on the third floor for the yoga studio build-out. So I can provide a documentation of that rescind order to allow the construction to proceed on the third floor.
Right, and I think that'd be helpful to provide us with whatever you have on DOB permits, because I think from our perspective, we're not granting this enlargement. That's something that the buildings department is doing.
Absolutely.
So, Commissioner Martinez, I know you had some questions. on
Right,
this.
that was my question, that you have the men's change room and bathrooms in the part that, to me, looked like it was subject to a stop work order.
Yeah, so I think what originally happened is the job was permitted, and then subsequent to that, there was the stop work order, and a lot of work was done within the building, including the entire frame of that third floor, of the addition. And then it was sort of at the end of the construction process that the stop work order was issued. And then we obtained a rescind to allow the build-out of the third floor space. But I can get whatever documentation and submit it to the board to hopefully clarify that issue for you.
Okay, and, all right. I guess the other question had to do with the CNE.
Yes.
And I just wondered, I'm curious, so the Landmarks has already looked at that enlargement at the back and approved that. So that's a separate CNE that you have. Is that
It was
correct?
a CNE for the enlargement and interior build-out on the third floor.
And what about the second floor and the first floor?
I don't.
Is the enlargement only taking place, I thought the enlargement's on all
Yeah,
three floors?
From what I understand, the enlargement was entirely in the rear for all three floors, and that CNE covered the enlargement plus the third floor interior build-out.
Okay.
I know there was a question about the PCE sign.
Yes.
So I raised that with the project architect, and basically he said it is a sign that is taped to the inside of the window, and Landmarks had informed the applicant, who was the property owner, that anything on the inside of the window, they're not going to exercise jurisdiction over. So,
Because it's a decal.
yeah, exactly. So, well, and I have photographs of that sign that if I can submit to the board, that actually show it is taped to the inside of the window.
Taped, okay.
Yes.
Right.
You can actually see
Lovely.
the Scotch tape mark.
Okay.
I have one
Yes,
question.
Commissioner.
You sent us a copy of a CNE, but in reading it, it looked like they were just approving some vent pipe. It didn't sound like it was the whole rear enlargement and the interior build-out. Is that a different one?
I'll take a look at it. I've realized, I think, the CNE that I had included that covered the build-out was just attached to the EAS. So I'll get the proper CNE and submit it directly.
All right, any other questions? Any speakers? All right, if you can submit that and get back to us, submit it to us on April 15th, we can have the hearing on April 29th.
Thank you very much.
Item number 13, calendar number 28513BZ, 495 Flatbush Avenue, Brooklyn, Warshore, Bernstein.
Josh Ryan-Smith for the applicant. This is another 7336 special permit, application to permit the operation of a fitness center within a portion of the ground and second floors of the existing building at the premises. I believe from yesterday's executive session, there was a question about the calculation of the permitted signage for the PCE.
Yes.
So the zoning resolution for buildings that have multiple establishments allow you to essentially treat each of the establishments as their own zoning lot for purposes of calculating signage compliance. So the PCE has 88 feet of frontage on Flatbush Avenue. The C8 district allows 6 times the street frontage, but in no event more than 750 square feet So 88 times 6 gets you 528 square feet of signage on Flatbush Avenue, the same on, I believe it's Washington Avenue, since it's a through lot. So that is how we came up with the permitted signage calculations, and I believe we have sign analyses as well as an elevation plan that demonstrate that.
Commissioner Martinez?
That was my question, and because of the other existing signage on the building.
Exactly. So each establishment is treated independently.
Okay.
Any other questions? Any speakers? Okay, we can close the hearing.
Chair Srinivasan?
Aye.
Vice Chair Collins? Aye. Commissioner Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Arlie Brown?
Aye. We'll set the decision date for April 29th.
Thank you.
Item number 14, calendar number 28613BZ, 2904 Voorhees Avenue, Brooklyn. Eric Palatnik.
Hello, good morning again, Eric Palatnik. We attended your review session yesterday, and we heard the discussion that the board had, and we'd like to offer some answers to some of your questions. There were 4 that we had. The first one you asked was, will the enlarged building affect the light and air of the adjacent property? I think you're speaking to the window of the building that's to the left of us, the home, single-family home that's to the left of us, to which we share a common lot line with. Our enlargement is going to be, when you look at the plans, it's going to be coming up towards the front of the home, and there's a porch, there's an open porch at the first floor level of our enlargement. That porch is where their window is, the open porch.
But doesn't it?
It also extends back. You've got a
second
two-story section, right behind the porch.
Yes, I don't believe they have a second-story window, though, on that home. I believe their window, we'll get you a clearer picture of just that window to show it to you. I think their window is only on the first floor of the adjacent home, and it's just that one portion where the porch is.
And you're not giving really a dimension between the two buildings. It appears that the adjacent building is very close to even your porch section, but to that two-story portion behind the porch.
So if you could just mention what the adjoining condition is, I think that's what.
Exactly. It
We'll
looks
mention
like
it, perhaps I'll give you some more photographs that are more specific to the window, and we'll update the plan to show the window, perhaps, of the adjacent home, so that you can analyze and understand it a little more clearly.
Yeah, it only looks like it's a couple of feet away, so.
Yeah, no, it's definitely just a couple of feet away. That home is about 1.5 feet off of the property line, I believe, give or take.
Right, so, but you're saying that because there's an open terrace, it looks into the.
It'll be looking into the porch area. It won't be looking into, it won't be facing the wall. It'll be facing the open porch.
Okay.
Okay, I believe the other question the board had was, I believe Commissioner Hinkson had the question relating to the driveway. We are proposing, you could tell from 29th Street, I don't know if you've been out to the property yet, 29th Street is sort of an offbeat street at this portion. It's a dead-end street. It's not fully improved to its full width. It is owned by the City of New York. It's not owned by our client. We'd be happy to include a note on the plans that would indicate that our client would build out that portion of the roadway plus 5 feet pursuant to the builder's pavement plan. Include that note on your approved drawing should your board decide to approve the application.
Okay, so your intent is to build out this portion, which.
I think Department of Buildings is going to require us to. That's been our discussions internally, that we think they're going to require that. The owner has had some previous discussions with the city about those pieces to try to demap the street, but irrespective of that, until that occurs, yeah, I think that's the approach that we would take.
So it's not really going to look like this. If you've got to do it to a DOT standard, you're going to have a sidewalk from your property line, not so much sort of grassy area.
Correct.
So it'll look like a 5-foot sidewalk and then a regular curb cut?
It should when it's done, completed, yes. They haven't prepared the building
And then you'll have to plant some
payment yet.
trees along there?
But your architect can just depict it more accurately.
Would you like us to, and then include a note saying that, or shade it somehow and say that that
Right.
area is subject to DOB approval to make it clear?
Right. Right, so I think what Commissioner Hinkson is saying is that the way you've drawn it out here, DOT is not going to let you do that. They'll make you actually look at it and construct it the way you would do a sidewalk. So it's a little bit, this is.
Yeah, this isn't for presentation to
Right,
DOB.
you've just shown us the
We're just showing for
existing
you.
condition, right?
Yeah, but I understand what your board is looking for. We'll do that. Go to the least discussion one next, which is the review of you asked about the streetscape with the pitched roof. You were concerned about the roof being flat. I spoke to the owner of the property. They'd be happy to put a pitched roof onto the property. It was his original desire for this, but we'll make it a pitched roof. And then the final question the board had related to the floor area. I think you were questioning why it is that we're asking for the floor area that we're asking for. It's about 1,980 square feet to be exact, a 1.1 floor area ratio. We are in an R4 zoning district, which allows as of right a 0.75 and then a bump up to 0.9 because of the attic ratio, the attic rule. What we are asking for is for a little bit more than that, to go to 1.1, and that enables to allow 3 bedrooms at the top floor and a 4th bedroom downstairs, which is what the owner is trying to accomplish here. It's not that big a home. It's still a little under 2,000.
But I don't think the justification can be based on what the owner wants to accomplish here. I think you're asking for a floor area waiver, and I don't think, at least up to now, you've rationalized to us why you need that additional bedroom or that additional square footage. So what I recommend that you do is, you've done an analysis of size of homes in the neighborhood.
Correct.
But I think you've only identified corner lots, and I don't see why there's a distinction between a corner lot and an interior lot. So why don't you actually look at the size of the homes and just make sure that we're talking about a single-family home? So you may find the square footage on some buildings as, 2,500, but it could be a two-family. I think we would just want to understand how it relates to other units
I'd be happy to.
in the surrounding area. I think that will bolster it, because then if you find that a 1,350 square foot home, which is what you can do as of right with the relief the board is inclined to give you regarding yards, then in that case, you could make an argument that the size of that home is too small as compared to essentially the neighborhood.
We'd be happy to address that, and we understand.
Okay, because it's not persuasive that they just want an additional bedroom. A 3-bedroom home is pretty.
Oh, I understand. That was one. Yep, I understand. One more thing, just to remind the board, I'm sure you're well aware, is that we are, of course, in Community Board 15, where the special permit would apply for the home, which the R1.1 is actually not as much as the board is routinely granted in the R4s. But we're not under the special permit provision here. Just wanted to remind the board.
All right. You can make that argument to us as well. Any other questions?
I just
Yes.
had a quick question about where you've actually placed your parking. It's, sort of perpendicular to the lot, and I'm wondering, was there an opportunity for you to actually have a curb cut on Voorhees and then enter into
I believe we're too
sidewalk?
close to the intersection on the corner of Voorhees, and that's what was causing the difficulty there.
And that you wouldn't also probably have enough width in the, in the front yard there? Would it take up too much?
Let me ask the architect what his rationale was for providing it there, because of course that would solve the problem with the roadway entrance on
Yeah.
29th Street.
Right?
Right, and it seems where the proposed driveway, it seems close to the intersection, but I guess that's not really a functioning intersection, so it doesn't really matter the way.
I'll find out what
I don't know.
the problem
What the
was from
rationale
providing
was,
it there.
if there was a problem coming in on Voorhees.
Okay. Any other questions? No speakers here, so we can continue the hearing.
We could submit in 3 weeks, just
All
because
right.
you have the holidays coming up in the next few weeks.
Okay, so April 22nd, and we'll continue the hearing on May 6th.
Thank you.
Item number 15, calendar number 31013BZ, 459 East 149th Street, the Bronx, Eric Palat.
Hello, good morning again, Eric Palat. We attended your review session yesterday, and we heard all the board's comments, and we'd like to address all the comments that we heard.
Okay.
Perhaps the most substantive of the board's comments was relating to our presentation of the arguments, and including a discussion relating to Section 73-19 and the information about the brokerage search. And we will be editing the statement to address, amongst other issues, to perhaps remove that. We were providing that for the board simply as a point of edification to show the good faith of the applicant that they did not just select the property that is in an M zone, but rather undertook a rigorous research of properties that they could locate at before they settled upon this property and this specific portion of this property, which I think goes to the remainder of the board's questions. And I would like to apologize to the board. We did submit to the board a draft statement when we made our edits to the notice of comments that was unfortunately not the final statement. So when we revise the statement to facts this time, we will submit to you a complete statement that has the proper one, and we do apologize for that. But nonetheless, the driving force for this variance request is two things for Metropolitan College. First of all, it's to have an adequate space, it's a sufficient size, with adequate light and air entering into the space, and that could be carved up in a somewhat linear motif. The problem, the question yesterday was, why can't we relocate the office space at issue to another portion of the building?
Well, I would question whether you have this larger floor plate and you have office space, and, yeah, exactly, couldn't this be reconfigured?
Let me explain to the board why it couldn't be done. The other side was looked at by Manhattan College prior to taking this side, and it was rejected by them. And the reason it was rejected by them was that the space, the way that it's carved up, the linear, the components of it, the angular shape of it, doesn't allow a linear carving of that side of it. So then the question comes up, why can't we potentially just move the office space over to the other side? And the reason we can't is because the side that we're on, which is the Brook Avenue side, is all or nothing due to the egress. As we called out in our paperwork, the egress, secondary means of egress, actually a tertiary means of egress, is required for this space because we're over 500 occupants. Because we're over 500, we're proposing, the program calls for approximately 719 students. Because we go over that 500 threshold, you actually need 3 means of egress, and we will include this whole discussion in our paperwork. Requiring the 3 means of egress, you'll see on the left side of the floor plan on that sheet, you'll see 2 staircases, which are 2 of the egress. And then on the right side, which is in the M zone where we are, which is subject to the variance, is the 3rd means of egress. If that was not allowed to be located there, then we would not comply with egress requirements, and we actually could have no occupancy by the college on that floor. They need to have 2 means of egress. And the 2 means of egress, as I'm sure the board knows, has to be a certain travel distance from one another. So the reason why we couldn't simply eliminate that space, although we may be able to eliminate the faculty office, which would require a lot of moving and a lot of reconfiguration of their program, the ultimate biggest reason is that the elimination of that space from the college's use eliminates the potential use of that floor by the college in its entirety.
But I don't want to be argumentative, but I think you've shown an as-of-right plan,
Yes.
which
The architect made a mistake on the
shows
as-of-right
the
plan.
egress, so you can.
The architect made a mistake. He shaded around the egress, if you'll see on his plan on the as-of-right, and that was an error. He should have shaded the entire portion there. You can't have, of course, as the board knows, you
He
cannot.
didn't shade anything. What he's done is he's shown a sort of unused area in M11 and a double height space, and then he's shown the egress.
You're looking at the as-of-right plan?
Yes, March 12th plans.
Second floor as-of-right, floor plan 4A, right?
Yes.
Okay. Yeah, as you can see there, he's showing egress through that area there. That's a mistake. He shouldn't be.
You mean as it's a college, they cannot use that?
They cannot use that because it's in the M zone. By being not permitted within the M zone, they're not allowed to egress it, much in the same way that you're not allowed to traverse through an M zone to reach a residentially zoned property.
And would this egress exist whether this school was here or not?
Yes.
Okay,
The
so.
egress is already designed, and the building is under construction.
Right. But they won't allow you to use it? That seems odd.
Well, it's not permitted to be utilized in the for the college use.
Right, I understand that, but the egress is for the entire building, isn't it? Okay, anyway.
No, that egress stair in particular is servicing that portion of the floor. The other side of the floor has their own egress stairs at the other corner of the triangle. So there's one central egress, there's one main in the corner, in the middle right here.
Right, okay, and it's just a 2-story building, is that
It's just a
correct?
2-story building, so you have the 2 in the
Understood.
corner. So that's really what's driving
understand.
the program.
Mhm.
We hope that helped the board. And we could proffer a couple of other reasons why the space is so desperately needed, which we'd be happy to put into our statement, and provide the board with some numerical calculations to show you the use of the space, how many students utilize it, things to that effect.
Okay, I think what would be helpful is maybe in your statement you can explain in a little more detail about relocating the space elsewhere on the site, and if that area is pinched, which is, I think, because I don't have the dimensions, but I'm looking at that leftover space, it seems to me this floor plate is anyway somewhat awkward because of the shape of the site. Really the corners where you get the most space, but what happens is if you actually move the school around, or the college around, you would have these two triangular spaces at the two ends, which don't make much sense for office. And alternatively, you relocated the school entirely within the zone where it's allowed, then it's sort of pushed to, I can't tell what direction that is, that it seems to be the western side, and it's very pinched in terms of its floor plate. So maybe you can just talk about that
We
a little
will.
bit. Okay, so that's one argument, and probably the second is that once you lay it out along this side, which is the eastern side of the site, then in that case, the required egress necessarily has to be within the M11 district.
Correct.
Or would have to cut back your square footage. But I know Commissioner Otley Brown had a question about the
Right, my
program.
question was that you had cited programmatic needs, but never really had a discussion of your program. And so the suggestion that the chair just put forth kind of addresses the programmatic need for a large floor plate that's more or less regular. So if you can incorporate that into your statement, that would address my issue.
Right, and just, I think, speak to the issue of what the student body is, and in terms of the justification of the general amount of square footage that you need in the classroom sizes.
We will. We'll
And the
do
fact
some
that
up.
actually the occupancy is driving the egress requirement as well.
We will.
Okay. All right, any other questions? Any speakers on this item? All right, we'll continue the hearing. If you can submit to us on the 22nd, we can continue the hearing on May 6th.
Thank you.